Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the respondent in this matter. Please grant him. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once we have come under Article 49J and 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyamo case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the Oyamo versus Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate, or they don't have access to his phones. What they did not tell you is that he gave them the passwords and they are keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the window. Let's finish that one. It's a simple thing, a 1-minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given him a password. Pick a password. Give the code. It is there. Just confirm. Yes. They are telling you.
Mr. Jibril. It's okay, you don't have to take it, eh?
Yes, the issue is not about the SIM or the password.
Yes. You can't take it.
It requires a lot of things.
No,
Okay.
Your participation. I'm running the show.
Yes.
Now they are telling you about witnesses. They are not telling you in the affidavit which witnesses, but they are telling you something else that is imaginary. That they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record the statement, did he appear? He did, and recorded a statement under inquiry. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, this headquarters CID, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the detention. Then have they convinced you, Your Honor? And I am saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say freeborn. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from these kind of people. The police. That is why you have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPOA. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I am certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them, but Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant these fundamental rights. Article 20, sub-article B. Might start by wanting to grant to ensure that this person enjoys the fundamental rights. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear articles. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? Refuses to answer questions. Tells he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves. Why should you believe him today? That once you release this person to him, he shall be treated well. Why? You cannot believe him because he denies publicly even his own boss. I know now how Jesus felt when Peter just said, and then, Yona, if that is the position, and then they come and tell you, oh, this, the public order and issues like that, and that the safety of this person depends on them keeping him in custody. Where does that come from? Because Article 29 is clear. This gentleman must enjoy his fundamental rights. The security, it is provided by the state. It is guaranteed. Guaranteed. So they can't come here by a mere application and tell you that he cannot be saved. And they don't quote that article in their application. Why? They avoid it intentionally because it is black and white and it is clear. So bad faith again from the investigating officer. And he is my friend. Now, Your Honor, I know when the state wants to respond, they will start telling you about probabilities. They want to tell you that nowadays it's on probabilities whether a person will appear or not, that they anticipate. And you can see from their affidavit, they are alleging, they are saying likely to abscond, likely to interfere. It remains likely. Let us change that scenario of likely. Let us move from the bail bond issues first of all. Let us go to what the law says today. Law is very clear, and there are three authorities that I will give the court. One I've already given, the one of Oyamo. Then there is one of Richard David Alden versus the Republic, that is number 40 something. Oh, you see, I'm even so confused myself. Richard Alden versus the Republic, that is in the High Court case number 48 of 2016. Simurai. Yes. And then the other one is Dwight Sagarai versus the Republic. That is number 61 of 2012 before the High Court. Proudly let me say that I appeared in the matters. What did the court say when somebody makes an allegation to do with somebody is going to interfere? The court did not say probably. The court said must put evidence, must show something, must produce something. Why? Because if we were to leave it to imagination, the sky would be the limit. So if you are saying somebody is interfering with witnesses, you must show that he directly interfered or indirectly or has attempted. In the affidavit that you have been given, nothing is there. They are saying likely. That was held by Justice Korir in the Dwight Sagarai case and was also supported by Justice Lesit as she then was in the Richard David Alden case. If you are going to say somebody is going to abscond, what does the judge say in Lesit? She says that you must be able to show that an attempt has been made by the person to try and abscond. Not only that, maybe there's a ticket, plans of traveling, or arrangements made. So I'll ask you, Your Honor, and I will give you the answer. Have they given you that? Then the answer is no. Such that even in the case of Oyamo, when they are saying that public order and public interest and all that, the court in Oyamo versus the Republic, and this is a court of appeal case, and that is the law. What does it say? For you to say that there is public order and rest and all those things that they are saying, they must show. All this unrest that has been going on has not been because of the OCS. Tuesday, tomorrow, there will be an mandamano in reference to somebody else. Not him.
You know, we hope that goes on record. from council. That matter of fact, we hope goes on record. We
Your
agree.
Honor, it's even on social media, and let me tell you why they can't tell me not to say anything about social media. In his affidavit, he said they got these issues from social media.
Your Honor, we admit that council can go to social media. We're just asking the court that as he says it from social media, please record it for us. We will use it.
Yes, Your Honor. And if that is the position that they are going to say and they are going to use it, let me tell you, Your Honor, it was not in relation to the OCS. It must be mentioned that it is the OCS and it must be accurate. Let us not generalize. That is why that law has never been overturned. Until today, it has never been overturned. So, what then does that leave the prosecution with? An empty shell, Your Honor. Today, they have come to this court, not, as I said, to do this case in a proper manner, but in bad faith, which have demonstrated, and an affidavit that does not meet the requirements of Article 49, and at least what they will come out from with here is that at least I've given them a definition of compelling reasons.
Yes. Thank you.
All right. That sounds.
Let me read. Cliff can mislead the court. Your Honor, for the public and the country to get that paragraph, that is the citation Cliff has said, criminal case number 61 of 2012, Republic versus Drat Sagar, in page 4, paragraph 3. Your Honor, the court is saying, for the prosecution, that is Owiti and my good friend Makori, to succeed in persuading you on this criteria, however, it must place material before the court which demonstrate actual or perceived interference. It must show the court, for example, the existence of a threat or threats to witnesses, direct or indirect, incriminating communication between the accused and witnesses, close familial relationships between the accused and witnesses. That is not Cliff Ombeta saying, but it was part of that decision. That is the decision that we are seeking. When I was cross-examining my good brother, he admitted he has nothing, no material before this court. Still, Your Honor, in that case, to read the final authority there, I agree with the holding in Panju versus the Republic, 1973, East Africa Law Reports 284, where the court, in dismissing the prosecution's fear of interference with witnesses, the court stated that before anyone can say there would be interference with vital witnesses, at least some facts should be led to the court. Otherwise, will be asking the courts to speculate. I don't know whether they will consider and say, release our person out of it. Your Honor, as a human being, because we have been arguing about the OCS as an office of the court, I want to bring to the attention that the respondent joined the police, and I wish it to on record. He joined the police in 1996 at the rank of a police constable. He has served the National Police for 29 years with a distinguished career. Central Police Station is the mother of all stations in this country. To be entrusted to be the OCS there, his integrity and his track record is unimpeachable. Number two, Your Honor, he's our father. And on that ground, as a father, he wishes to pass condolences to the family of the deceased. As a father. As a husband, he seeks this court to take judicial notice that he has a home in Eldoret. And is ready, once the court agrees with his application for bail, not to set foot, not only in Central Police Station, but anywhere in Nairobi and the environs. He is still a police officer, though on interdiction. He understands the weight of trying to get contact with the witnesses. He knows it. You know, this is a man who has given gallant service to this country in far remote bandit-prone regions. Until now, he's here. He has served this country with a lot of dedication. He is not afraid to be investigated. He's not afraid to be investigated. He stands innocent before this court and before the whole world. And according to his advocates, the manner in which the state has arraigned our client here is suspect. There are other extraneous reasons as captured, Your Honor, in this case. The last authority I will give you.
Sorry.
I'm only reading out.
Sorry, Your Honor. Before you read the authority, counsel should be kind enough when he accuses the state of having extraneous factors to share with us an affidavit just proving extraneous factors. Otherwise, he has done a very good job for his client in the seed the ground so that we do the...
I'm finishing with an authority.
All right.
Except that I didn't want to say that it is purely political to bring this officer here. He's not here because he has committed an offense. He's here either by virtue of the name.
You know, Mr. Omari would go and go. We object to the line that is going to those extraneous factors, including politics.
The last authority.
Senior, let me finish objecting because you will do
it. You will open a bigger Pandora box.
Yeah, let me finish objecting.
Because you can't persecute somebody by virtue of
Your Honor, kindly.
Yes, let Mr. Witi finish.
We are objecting to the line that counsel is taking with the suggestions of extraneous factors and political arguments which are not substantiated with any affidavit. Counsel knows that he cannot give us facts from the bar. So he has done a good job on the law, the team has done a good job. I think he should not water it down with innuendos.
You know, lastly,
Mr. Omari, I think you...
It's the last authority
okay.
They have had. They have had. In the High Court of Kenya at Mombasa, Judicial Review number 93 of 2011, Hassan Kinako Sup versus the Attorney General and the Commissioner of Police. This is a judgment by Justice Edward M. Murray, dated the 17th day of July 2014. You and I refer to paragraph 8, and we have given a copy to the state, and we have given a copy to the court. Your Honor, paragraph 8, the learned judge says, I therefore find that the Director of Public Prosecution is under statutory duty under Section 388 of the Criminal Procedure Code to institute an inquest proceedings before a competent court in terms of Section 387 thereof. I also consider that the court should give effect to the deceased's family interest in knowing how the deceased met this death for emotional relief and establish whether there was any criminal or tortious causes which may attract consequences in penal and pecuniary redress. Your Honor, nobody should stop the court to look at the law as it is, whether that law has been argued on this floor, or so long as that law we are mentioning is in statute. Whether lawyers don't argue it, whether lawyers don't present it in form of appeal, the court is duty-bound to look at the law. Does it have jurisdiction to sit in this matter, or it needs to be declared an inquest court so that we move to the scene of the crime and that's what starts? Your Honor, that is for the abundance of caution that the court have given you the authority. You will assess whether this matter, and now Mr. Whitty can understand what I'm saying, flagrant disregard to sections of the law that are statutory is political.
So
That is why,
Mr.
my
Mr.
friend,
you've made your point, yeah?
we have no more.